If I knew I was going to get a backpack, I would have drove up to LA and back. Well, thanks everybody for coming out. Appreciate it very much. I see some familiar faces. As Travis said, Carla and I are going to be speaking today. And at this time of year, I always focus on what the new laws are that have been passed by the California legislature that employers need to be concerned about. Luckily this year, there's not too many, and they're not too onerous, but there are a couple of things that I think are important for you as administrators or HR or finance to be aware of as we go into the new year. And these are new laws that are going to apply to all employers. So it doesn't matter how many employees you have. It doesn't matter whether you're a religious corporation or just a nonprofit. These are laws that everybody's going to have to comply with that I'm going to be walking through. And then Carla's going to talk about a couple of things that are more specific to religious organizations, including some things about what you need to do to make sure that you're in compliance, because there's certain postings and other things that need to be tailored to religious organizations. And then at the end, we're going to have question and answer. So it's going to be an AMA. You guys are familiar with an AMA, right? Actually, it's going to AUA, Ask Us Anything, at least in terms of HR and employment. So we'll do that at the end, and we'll be happy to answer any questions that you have. So I'm going to start out by talking a little bit about these new laws. And the first one, and the one that's probably got the most going with it, is SB 294. This is a law that is going to require all employers to give a written notice to employees regarding their rights. So Carla's going to talk a little bit about, the typical labor law posters that, we all use in the workplace. This law goes a little beyond that and says that now there actually has to be written notice given to employees, including new hires. And we'll talk about what that's going to look like and what you're going to have to be prepared to start doing effective January 1. So this is known as the Workplace Know Your Rights Act. So you may hear that referenced out there in the media. And basically, as I said at the outset, this applies to all employers. So we all know that there's some laws that apply if you've got 50 or more employees, or there's some laws that apply if you have 5 or more employees. This one applies to everyone. And what this law says is that a standalone written notice must be given to all employees each year effective January 1st, 2026. And I really want to emphasize standalone, right? This is not something that we can just rely on the labor law posting to meet the obligation for. We need to actually have a standalone document that is provided to employees. Now, the notice can be emailed or texted even, if that is a method of communication that you typically use when you're communicating with employees. I'm going to give you one watch out though, okay? That is, when it comes to texting, you need to be very cautious that you are not texting business-related information to employees on their personal cell phones. Because if you do, that gives the employee the ability to claim that their personal phone was being used for business purposes, and therefore I am entitled to reimbursement from the employer for a portion of the cell phone costs. So if you've got employees that have phones issued by the employer, no problem. but just be very careful, just in general, not just with these notices. And we're in a world now where texting seems to be the most common and efficient way to communicate. So a lot of people, employees included, are dependent on texting. Just be cautious. You don't want to, for instance, text people direction about how they're supposed to perform their job on their personal phones, because now it's a business use and you got to reimburse them for it. Okay? So, it could be electronic, but doing a piece of paper, analog in a digital world, that also works. So we'll talk about what that's going to look like. And as I mentioned, it must be provided to employees upon hire. So it's got to be another thing that you put in your hiring packet, right? All right. So there is going to be a template notice developed by the Labor Commissioner. I'm smiling here. On or before January 1st, 2026. It's going to be like the bullet train, all right? It's going to. I have my doubts, and we've experienced this a couple of times where they pass these laws and say, "Oh, the Labor Commissioner is going to develop it," and it doesn't happen on time. So, my point is that yes, keep your eyes open for that template because it will be a useful thing to use, but don't depend on it coming out by January 1st because it would not surprise me. And even if the template doesn't come out, you still have to comply, okay? But I just wanted to highlight that there is a template that is going to be coming out. All right, so what is this notice going to look like? It has to advise employees of certain rights. And let me just go through these bullet points. The first, it has to advise employees of their right to workers' compensation benefits and the contact information for the Division of Workers' Compensation, which to me is really silly because already the Labor Code 2810.5 form requires you to give workers' compensation information to employees. But, hey, I'm not in the legislature, so they thought, no, we need to include that in there. So that is one aspect of what needs to be included on the notice. The second, and this is really what this law was designed to do, is to give employees notice that if ICE is going to conduct an inspection of your I-9s, that the employees will receive 72 hours notice. So on the notice form, it has to say, if we are subjected to an I-9 audit by ICE, we will be giving you notice that there is an I-9 audit going on at least 72 hours before the audit date. So that is really the way this law has been characterized in the media is to know your rights about immigration enforcement. And that was really the main thrust of the legislation. So this is the second part of it. It needs to advise employees about protections against unfair immigration-related practices against employees exercising protected rights. So under California law, if employees, for instance, provide certain documents for their I-9 verification and the employer doesn't take those documents as valid and they don't have a good reason, that would interfere with employees' immigration rights. So the notices have to advise employees of the rights that they have under California law to be protected against unfair immigration practices. Also, interestingly, the notices have to advise employees of their rights to organize with a union or engage in protected activities. So this is an interesting thing going on right now, just as a side note. As you know, the federal government shut down, which means certain things having to do with labor unions that are administered by the National Labor Relations Board are also shut down. So California has stepped in and said, well, we're not going to rely on the federal government anymore. We are going to take the affirmative step of requiring employers to advise employees of their rights to unionization. And there's a whole thing that's going to be going on about whether or not this is preempted by federal law. You probably don't have to worry about that, but you do have to worry about the fact that your notices to employees have to have an advisement on rights to unionize and engage in protected activity. And lastly, and this goes back to the immigration piece, it has to advise employees of their rights under the Fourth and Fifth Amendments to the Constitution when they interact with law enforcement officers in the workplace. Okay, so this is really directed at if ICE agents show up. What are your rights as an employee in terms of illegal search and seizure and having an attorney and not waiving your rights to self-incrimination? So all of that has to be included in this notice to employees. And again, the template is supposed to show the model language for this. I wouldn't rely on that. You need to do your own research and figure out what your notice should look like. And then when the template comes out, if it does come out before January 1st, great, we can compare it and make sure that it's compliant. But if not, at least you've got something ready to go on that date. Another part of this legislation is that we are now, as employers, required to give notice to employees that they can let us know who their designated emergency contact is. And this has to do, once again, with immigration. If the employee notifies the employer that they would like their emergency contact notified in the event they're detained or arrested at the workplace, then the employer is obligated to then give notice to that emergency contact. So-and-so, your husband, your spouse, your child, whoever, has been detained or arrested here at the facility. So there is a requirement to give that notice if the arrest or detention is during work hours or if they're performing job duties. But if they're not at the work site when it happens, but they're on company business, you only have to notify the emergency contact if you have actual knowledge that they've actually been detained, right? If the first call from the employee is, hey, I'm out making a delivery and I've been pulled over and ICE is detaining me, now you have actual knowledge, you have to notify the emergency contact. So you must provide employees an opportunity to name their emergency contact by March 30th of next year, or at the time of hire. So again, this is another form that we've got to give to employees to basically say, hey, if you want to let us know who your emergency contact is in case you're detained or arrested at work, please give us that information and we will notify that emergency contact if you're detained. So from a compliance standpoint, number one, with the notices, I think you have to have something like most of other HR forms where the employee acknowledges that they received and have read and have understand the notice. And secondly, that employees acknowledge that they have received notice of their ability to designate an emergency contact and that the employer has notified them of their rights to have that emergency contact notified in case of arrest or detention. So again, I know this really makes you happy. More paperwork. Isn't that great? But it's important to have this documented because the law specifically says you got to keep these records for 3 years. And if there is a violation, it's a penalty of $500 for each employee for the notices. So if you didn't send out the notices and you've got 10 employees and the labor commissioner shows up and says, where's the notices? Where's your proof that you gave notice? Well, we don't have that proof. Okay, I'm going to issue a penalty of $5,000. And then for the emergency contact, the penalties are even greater. It's $500 per day up to $10,000 per employee for failing to notify them of their rights to designate an emergency contact. So from a compliance perspective, we have to make sure that our paperwork's in order and that we store it for at least 3 years. Now, if it's paper and you digitize it and you store it electronically, that's fine. But there has to be something where if the labor commissioner shows up, and I've had this happen recently, the labor commissioner is now sending out their investigative teams to do random audits. And just out of the blue, companies are saying, hey, somebody's saying they're from the state labor commissioner showed up and they want to see all my documentation. So I expect that that's going to happen more frequently in the future, and they could show up anywhere. So it's, just because you're in the nonprofit world or a religious corporation, that doesn't insulate you from somebody from the labor commissioner just showing up, because it looks like they're just pulling names out of a hat from what I've seen so far. So just be aware of that. All right. Second, AB 692. This is a ban on what are known as stay or pay agreements. And some of your organizations may have used these in the past, maybe with some of the ministerial employees, people that you're recruiting to come from out of state, and you say, hey, we're willing to pay you a bonus or some sort of compensation, but if you don't stay for, let's say, 2 years, you got to pay us back, right? That's what a stay or pay agreement is. And, what happened was, and I've had this from clients over the last years, everybody was trying to put the square peg in the round hole with this. And, I had to spend a bunch of time training my employees, and that's a cost to the company. So if the employee leaves within 2 years, they should agree to pay me back the training costs. Okay? And, I am sending this employee out to training, but it's training that I'm requiring for them to be able to perform their job. But if they leave after I make this big investment, I want them to pay me back. And so the legislature stepped in and said, no, we're not going to allow that anymore. So what this legislation says is that any employment agreement that has to do with training, tuition reimbursement, relocation fees, licenses, we are not going to enforce it. It is going to be considered illegal as of, again, if it's entered into after January 1st. Okay? So a current agreement does not fall within this law. But if you're an employer, and again, this applies to all employers, after January 1st, 2026, and you make an employee sign one of these agreements, it is illegal, it is void. So that's what the law says, unless it meets certain requirements. So it is unlawful to require an employee to execute one of these agreements to pay a debt or incur a penalty or a fee or a cost if the employment terminates. Now, there are some exceptions, which we will talk about. But again, the penalty is pretty severe. Violations can result in actual damages to the employee or $5,000, whichever is greater. And here's the kicker, plus attorney's fees and costs. So if an employee sues saying, hey, you made me sign an unlawful agreement, and they win, their attorney is going to be entitled to an award of attorney's fees. And something I've mentioned in the past, since this is part of the labor code, you could hypothetically, if you had multiple employees required to sign unlawful agreements, be subject to a PAGA lawsuit, because it is a violation of the labor code, and therefore the employees can sue on behalf of other employees under the Private Attorneys General's Act. So we need to be really careful about this. Now, as I said, there are some exceptions. First big exception is tuition reimbursement. Okay? If the employee is getting a degree, some sort of credential, and the employer is footing the bill, you can have an agreement that they pay a portion of that back upon termination, but it's got to meet these requirements. Okay? First of all, it's got to be separate from the contract of employment. So you can't slip it into the handbook. You can't have it part of an overall contract of employment. It's got to be a separate standalone agreement. Okay? Number two, it's got to be a transferable credential that is not required as a condition of employment. In other words, it's something that the employee could use no matter where they were working as part of their career, as opposed to a specific certification that is required for their position. Okay? Number three, the repayment amount has to be specified in the agreement, and it cannot exceed the cost to the employer for the tuition reimbursement. And if the employee leaves during the repayment period, it's got to be prorated, right? So if you're requiring the employee to stay 24 months and they leave after 18 months, then whatever they owe has got to be prorated based on the length of time that they worked there. In other words, they're only going to owe a quarter of what the repayment obligation is because they stayed 18 out of the 24 months. You can't accelerate it at the end. Oh, no, you left before the 24 months, so we're going to make you pay the full amount. Can't do that. If you terminate the employee, you can't go after repayment unless you can prove the employee engaged in misconduct. So I've got misconduct in quotes because what this refers to is under the unemployment code. Has anybody ever gone to unemployment insurance hearing with EDD to challenge somebody's unemployment? Right? What's the standard? If you want to challenge somebody's eligibility, either you got to prove that they voluntarily terminated or that they engaged in misconduct. It can't be just they were a poor performer. They had to do something really bad. Okay? So that same standard is what is adopted here. So if the employee quits, you can require repayment. But if you terminate and you require repayment, you've got a high standard to meet. So just be aware of that. So that is one of the exemptions. The second exemption is like hiring bonus agreements that are not tied to specific job performance, again, are exempted. If you say, hey, I'm going to give you a hiring bonus of $25,000 to move out here to California and to take on this job, but you got to stay 2 years. That can be an enforceable agreement if it meets the qualifications, the requirements. Number one, same as tuition reimbursement, it's got to be a separate agreement from the primary employment contract. Two, you got to give employees notice of their right to consult an attorney, and they have to be allowed 5 business days to seek advice prior to signing. So this is separate from the tuition reimbursement. For these types of agreements, you've got to have some advice there in the agreement itself, and you got to give them 5 days. Again, you've got to prorate based on the amount of time that they stay, and it can't exceed 2 years. So that's different from the tuition reimbursement. These types of agreements, you can't make them repay if they leave after 2 years. That's your limit. The employee has the option to defer until the end of the retention period, and the separation has to, again, either be voluntary or due to misconduct. Okay? So, yes, sir.
So if we had an out-of-state pastor coming in and we were to say, California housing market is tough, we'll give you a loan of $100,000 and it's paid off if you stay 5 years. If they leave after 2, we cannot correct any of that.
If they leave voluntarily and you had an agreement that met all of those requirements that I just covered, then you could collect that. But if you didn't have an agreement that met all those qualifications...
It's assuming we met all the qualifications. That 2-year limit confused me.
It's the 2-year limit, right. So because it's beyond 2 years, that would not be enforceable. It would only be enforceable up to the 2 years.
Okay, so basically we could do it and collect the balance of our money.
Yep. Okay. Yep. That's right. Yes, in the back.
Employer requires you to take a course or conference or whatever. Are they obligated to pay for that conference?
Yes. Yes, because you're requiring it as a condition of employment. And under Labor Code 2802, an employee that incurs an expense that is necessary to carry out their duties is entitled to reimbursement from the employer. So if you're requiring somebody to go to a conference or to training or something like that, you got to pay for it. If, on the other hand, the employee says, I want to go get an MBA, and you say, okay, we are going to reimburse you for the cost of getting that transferable credential, but you got to agree to stay. Now you have to comply with those requirements that I set out for that agreement in order for it to be enforceable. Now, just to piggyback on what you said, that 2-year rule only applies for bonuses. It does not apply for tuition reimbursement. So hypothetically, you got an MBA candidate, you're paying big money because they're going to a private school to get their MBA. You could require a longer period for them to stay than just the 2 years. But if you're doing a relocation bonus or something like that, 2 years is your limit. Good question. Yes?
On the notices, you mentioned we could email or text. If you do an email, is a read receipt enough?
Yeah. Yeah. The question was, if you do an email notice, is a read receipt enough? I think so, but you got to store it for 3 years, right? You got to have some proof. I mean, I think it's preferable to have something scanned back with the employee's signature, but as long as you have some proof that, yes, we gave notice to the employee and they received it, I think that would be sufficient. Okay, I got 2 more slides, and then I'm going to turn it over to Carla. This first one, I wanted to mention it. It is something that we need to be aware of because it does affect all employers. It doesn't come up very much, but it is out there. And so this is SB 642, which is known as the Pay Equity Enforcement Act. So the big thing that this does is it changes current law. Current law says that when you're required to provide pay information to employees, or if you have more than 15 employees, you have to put it on a job posting. Is everybody familiar with that? Okay, so there was this whole thing about, well, what kind of pay information do you have to put on there? And under the previous law, it was pretty much an expected scale, right? So what SB 642 says is that that pay scale that you were expected to pay for that position is not enough. It's redefining what you need to provide. Now you have to give a good faith estimate of the pay rate for the position that you are posting for or that you're hiring for. So now you can't just say, hey, we generally pay between $20 and $30 an hour for administrative assistants. You have to say, we expect to pay $25 an hour for this position that we are posting or this position we are hiring for. So again, keep in mind, if you're putting out job postings, you're going to need to be more specific than in the past. There's also an expanded definition of gender. So gender equity rules, that's what pay equity is mainly focused on. Used to be based on male or female. Now it's non-binary genders. So it crosses people who say they have no gender or anything like that. You got to meet the equal pay requirements. It's not just limited to you can't have men making more than women doing the same job. The other thing is that equal pay now includes bonuses and expense reimbursements. So equal pay used to be based on wages, like straight wages. Now you can't have a situation where men get this level of bonus and women doing the same job get this level of bonus or this level of expense reimbursement. It's broadening the definition of wages. Speaking of wages, last thing, just to mention, it's January in a couple months, and of course that means the minimum wage is going up. The minimum wage is going up effective January 1st, and it will be $16.90 for all employers. More importantly, however, the exempt salary is going up. Every time the minimum wage goes up, the amount of salary you have to pay people for them to be considered exempt from the labor code goes up. So currently it's 68 and change, now it's going to over 70. So if you've got people that you're treating as exempt and you're paying them, I think it's 68,640, you're just right on the number, okay? You're going to have to look at increasing that if you want to keep them as exempt effective January 1.